Good afternoon, everyone, and welcome to our webinar on digital marketing and advertising, the legal side of AI, NFTs, virtual influencers, and dark patterns. My name is Jamie Lynn Kraft, and I'm a principal in the trademarks practice group at Smart & Biggar. I'm joined today by my colleague, Alice Sang, who is a principal in the life sciences practice group. Both of us are also members of our firm's marketing and advertising law practice group, and that's the area that we're going to be focusing on today. That's us. And this slide shares a little bit about our firm. We are proud to be Canada's leading IP firm with offices across the country and expertise in all areas of IP, including trademarks, patents, industrial design, litigation, internet law, marketing and advertising, and related areas. Before we get to the substance of the presentation, I want to let you know a little bit about what you can expect over the next hour with us today. Our formal content is going to be followed by about 10 minutes of questions and answers. And while we're saving time for questions at the end, you shouldn't hesitate to submit your questions at any time during the presentation by typing them into the Q&A panel, which can be accessed by clicking the Q&A button at the bottom of your Zoom screen. Now, this is an important point. The Q&A button is different than the chat button, so be sure you're submitting your questions into the Q&A panel and not the chat. Today's webinar will be recorded, and following the presentation, we're going to be circulating an email to you with a replay link, so you can watch this again and again to your heart's content, and the slides will be visible in the replay. At the end of this webinar, a link is going to pop up for you to complete a survey. And we'd really appreciate it if you could take a few minutes to complete the survey with your feedback on today's webinar, and also let us know what other topics you might be interested in learning more about. And with that, let's get started. Here on this slide is our agenda for the webinar. We're going to be tackling 4 timely topics in the field of digital marketing and advertising. I'm going to address artificial intelligence. Alice will then speak to virtual influencers and dark patterns, and I'm going to end with a discussion on NFTs. And then, as promised, we'll have our Q&A session. Artificial intelligence, how AI is used in marketing and the legal implications. As a first step, it's helpful to understand what we mean when we say artificial intelligence or AI. Does it mean that the robots are taking over? Well, there's varying definitions of what artificial intelligence is, and some of them are here on this slide. It could include the capability of computers or programs to operate in ways believed to mimic human thought processes, such as reasoning and learning. It could be thought of as intelligence demonstrated by machines. In many cases, what we're talking about is data inputted into an algorithm, which then results in automated decision-making. So that's AI. The next question is, what sort of applications does AI have in marketing? Well, AI has completely changed the marketing game, and its applications are far-reaching. It can be used in data analysis. So think of collecting and analyzing huge amounts of marketing data about consumer behavior that would otherwise need to be collected and analyzed by humans at a much slower rate. And indeed, it probably wouldn't even be possible to capture all that data manually, considering the sheer magnitude that's generated these days. A really interesting application for AI in marketing is content generation, including natural language processing. So, think of those customer service bots that you encounter on websites. It pops up, oh, can I help you? And they can carry on fairly sophisticated conversations, even though there's no human behind them. AI can also be used to write video captions, email subject lines, web copy, and blogs. AI can be used in media buying by predicting where and when to place ads to reach the target audience. So advertisers don't want to waste their ad spend by, for example, showing me ads for monster truck rallies when I don't really care about that sort of thing. AI can also be used to personalize a user's experience on, for example, a website, a social media platform, or in an email to align with that user's preferences based on their past interactions with those marketing assets. This personalized experience makes customers feel good and thereby generates brand loyalty. So the bottom line is, AI allows marketing teams to operate more efficiently, and in particular, to boost return on investment on marketing campaigns. But while AI can be a good thing, marketers should proceed with caution. And I'm going to share one cautionary tale with you about AI gone wrong. A few years ago, Microsoft introduced a Twitter bot named Tay. So this was a Twitter account which was operated by artificial intelligence. Tay was designed to chat with people on the internet and become smarter the more it conversed. This was supposed to be an experiment in conversational understanding. Well, with the internet being the internet, trolls came along and taught Tay some very inappropriate words and concepts. Within a mere 16 hours of its release, Tay had tweeted more than 96,000 times, and Microsoft had to suspend the Twitter account because Tay had turned into an offensive, vulgar, and racist bot. So that was a bit of a PR pitfall resulting from the use of AI. But what about legal pitfalls? Well, there's been some pushback from the consuming public regarding the use of AI, including in the marketing context. There's some discomfort regarding the degree to which personal information has been used to target advertisements and conduct other marketing activities. The regulators have heard this and are taking steps to address these concerns. I think the quote on the right side of this slide sums up some of the perhaps stronger views against some of those practices. Abroad, there are two notable examples of proposed regulations, which, if passed, would impact the ability for marketers to use AI in advertising in those jurisdictions. In the US, a group of Congresspeople introduced the Banning Surveillance Advertising Act, which is aimed at prohibiting advertising networks and facilitators from using personal data to target advertisements. If passed, it would prohibit advertisers from targeting ads based on protected class information, such as race, gender, religion. In the EU, we have the Digital Services Act, which is part of a proposed regulation where one of the obligations includes a ban on targeted advertising on online platforms by targeting children or based on special categories of personal data such as ethnicity, political views, or sexual orientation. So what's happening in Canada? Well, in 2022, the Canadian federal government introduced Bill C-27, which included among it the proposed Artificial Intelligence and Data Act, or the AIDA for short. If passed, it would be the first Canadian law to regulate artificial intelligence systems. The stated purpose of the AIDA is to regulate AI systems used in commerce and to prohibit certain conduct related to those systems that may result in harm. The AIDA would essentially cover any use of an AI system by a private sector organization unless they were exclusively operating in a single province. The proposed act defines what it means by artificial intelligence system, and as you can see by the definition on this slide, it's similar to the definitions we saw at the beginning of this topic on artificial intelligence. What obligations would the AIDA impose? Well, it depends on whether or not the AI system in question is a high impact system or not. So all organizations using any AI system in commerce will have some obligations, including establishing measures relating to anonymized data, assessing whether or not their system is indeed high impact, and certain record keeping requirements. Where a system is deemed to be high impact, the obligations are more burdensome, including establishing measures to identify, assess, and mitigate the risks of harm or biased output that could result from the use of the system, establishing measures to monitor compliance with the mitigation measures, publishing a description of the system, and notifying in the event of material harm. The proposed AIDA has some teeth. The max penalties could be up to the greater of $25 million or 5% of the organization's gross global revenue. So there is a fairly significant incentive to comply. But a key question is, what is a high impact system? And I just see on the question panel that someone just asked that. You predicted my next slide. Well, We don't know. This is going to be set out in the regulations, and it's not yet defined. So we don't have clarity on this point yet. I think it's fair to speculate that certainly something like an AI system employed, let's say in a healthcare setting, where decisions about patient care are being made using the system, would be likely to be considered high impact. Imagine, for example, racial bias in an AI system impacting the quality of care that a person receives. Now, in contrast, a marketing campaign which uses AI to show targeted ads for dresses or handbags to me because I'm a woman, while biased, does not appear likely to cause me any harm, so as to make the system eligible for increased regulation. But consider instead an AI marketing campaign which offers certain discounts or financial benefits to specific consumers, which is based on racial or gender biases. Or what about a real estate ad for a new condo where timing of when you buy a condo can impact the price that you pay, or car financing ads for limited time preferential interest rates? Since there's a potential for economic loss, or at least no economic gain compared to others, would that be enough to justify further regulation as a high impact system? This all remains to be seen. It's also worth noting that Bill C-27 also contains a draft Consumer Privacy Protection Act, which would require all organizations to provide a general account of its use of any automated decision system to make predictions, recommendations, or decisions about individuals that could have significant impact on them. And on request by an individual, provide them with an explanation of the prediction, recommendation, or decision. So notably, unlike the AIDA, these obligations under the Consumer Privacy Protection Act would not distinguish between impact levels of AI systems. They would apply across the board. So Bill C-27, which includes all of these proposed acts, needs to go through a second reading and debate. It could be changed before receiving royal assent. And then, of course, those important regulations about what is a high impact system, those will need to be drafted. Now, of course, even without this proposed legislation coming into force, the private sector is already taking steps to address consumers' concerns. Indeed, earlier this year, Facebook announced that it would remove detailed targeting advertising options that relate to topics that people may perceive as sensitive, such as referencing causes, organizations, or public figures that relate to health, race, ethnicity, political affiliation, religion, or sexual orientation. Notably, the interest targeting options that Facebook is removing are not based on a person's physical characteristics or personal attributes, but instead on things like a person's interactions with the content on the platform. In that way, Facebook's actions actually go further in limiting targeted advertising than the proposed regulations that we've discussed here. That is something that marketers should take note of, since other platforms are likely to follow suit. And with that, I'll turn it over to Alice to discuss virtual influencers.
Thanks very much, Amy Lynn. That was a terrific overview. So I'm going to be discussing virtual influencers. Virtual influencers are basically just a digital version of human influencers. So we already have human influencers, celebrities, actors, lots of different talents, and now you can have digital influencers. Some feel more lifelike than others, and I'll give you some examples shortly. The top virtual influencers have large social media followings and make significant amounts of revenue for their creators. Virtual influencers can be created by a marketing agency and be used for multiple brands, or it might be one brand, creating a virtual influencer just for its own brand. Or alternatively, it could be a brand-specific virtual influencer who then, because they're so popular, they end up promoting other brands, which is quite interesting. So these are just a few examples. The Vogue cover page on the left, the top person, she is Lou from Magalu. She is Brazilian. She started off as basically a digital sales rep for the behemoth Brazilian store Magalu, and Then she became so popular that she has now like over 50 million followers. You may or may not be aware of her, but at least in Brazil and certain area of the world, she is huge. The person on the left, also Brazil, La Michela, she was created in 2016. So she started her life in quotes, on an Instagram account. And only a few years later did she, was it revealed that she was a robot. And she is now globally one of the top influencers virtually as well. She does promotions for brands like Prada and Calvin Klein. Jamie Lynn, can you go to the next slide, please? This is an example of a Japanese virtual influencer and also Nobody Sausage on the right. And this is an example of Hugo Boss. They're trying to change their branding, so to target the younger demographic with their new brand Boss, and that's targeted for millennials, 25 to 40-year-olds. And so these are some of the virtual influences they're now using. For the next slide, we're all fond of KFC. So on the left, a real person. On the second to the left, we're all familiar with that. And then the one with the red and white background. So KFC originally intended this to be tongue-in-cheek, perhaps, kind of mocking digital influencers, and yet it was very popular. And so this for KFC virtual influencer ended up promoting other brands. So you'll see the image on the right, that's Dr. Pepper. And, he also promoted TurboTax and Old Spice. So, what started off as maybe something fun or a joke, it became pretty popular. Can you go to the next slide? And I will talk about this one in a few minutes. So in terms of some of the benefits of virtual influencers, there are a ton. Let's see. They can be utilized 24/7. What someone had said was virtual influences are easier because they don't sleep, they don't have off days, they don't become sick, and they are never unavailable. So virtual influencers, unlike humans, can do a lot more. If you have a human influencer, perhaps they are, a soccer player or a ballerina or an actress or a model. But if you have a virtual influencer, they can do all of the above. And they can do all of the above in the same day, at the same time, right? A logistical issue, no border problems either, right? Crossing borders. So that's a benefit. They never age and they never die unless you choose them to. Another benefit is they are, some people would say 100% controllable. I don't think that's quite right. I think certainly with a virtual influencer, there's a lot more control, but nothing is ever 100% controllable. So as an example, if you have a virtual influencer, the content that they generate, the information, it's still based on an actual creator now, right? So there's been an example of maybe the creator made the virtual influencer say something controversial, for instance, something regarding Taiwan that may have upset China, for instance. Or you may have issues where you have a virtual influencer that it's being used with multiple brands, and therefore the virtual influencer is associated with multiple brands, but one of the brands, was embroiled in some sort of scandal. So then that links back to your brand, even though you're using a virtual influencer. Finally, leveraging off what Jamie Lynn said, from an AI perspective, right now, certainly AI can be used for virtual influencers. Right now, I think that most companies, most brands probably don't want AI to be, don't want their virtual influencer to be exclusively controlled using AI for the reasons that Jamie Lynn mentioned with respect to the Microsoft Tay bot example, right? That would really be a bad PR issue. What are some of the negatives with using a virtual influencer? A big challenge is making people care about the virtual influencer. So because this is novel, a lot of people are interested in it now. But the creators and the brands that use virtual influencers, it is work to ensure that the virtual influencer stays relevant. Body image perception, and that's not specific to virtual influencers. Certainly with human influencers, that's an issue as well, right? But typically when you create virtual influencers, you're creating someone who might be something who might be perceived as desirable in terms of body traits. And that can be hard for certain consumers, and that's what they see. Although it's interesting because one person said, actually, I'm not like, body image is less of an issue with virtual influencers because I know they're not real. So another one is deep fakes with virtual influencers. It's easier to have deep fakes, and so that could be another issue in terms of potential PR scandals. And finally, when you have influencers and they're endorsing a product or a service, they're actually supposed to be, in many cases, proclaiming their own opinion regarding something, right? So if you have a virtual influencer saying, I love this yogurt, it tastes really good. Well, the virtual influencer didn't actually taste it, right? So that's a bit of a negative from that respect. Is it worth it for a business to engage in virtual influencers? A couple of things to keep in mind. In the long run, it could be cheaper than using a human influencer, depending what kind of human influencer you use. In the short run, if you're planning on creating your own human influencer, it's probably not cheaper. You're probably better off hiring an existing virtual influencer because it takes a lot of both creative and technical effort to create a good virtual influencer. So it's not a cheap endeavor, certainly not something that if you're only planning on using it short term. It probably depends on your market. So virtual influencers are very big already in certain countries in Asia. And apparently the engagement with a virtual influencer can be 3 times as high as engagement with a human influencer. I don't know how sustainable that is, but at least that was one of the stats. And the reality is virtual influencers are probably going to become even more ubiquitous in the future for a couple of reasons. Greater acceptance of digital culture, the metaverse, that's one aspect. And the second aspect is it's just going to be a lot easier from a technology perspective. So easier and cheaper, faster to create virtual influencers. So this is definitely not something that's going to be going away. A few things I wanted to flag from a legal and risk perspective. Misrepresentation. So I think most of us probably know that when you use an influencer, you need to disclose, the fact that this person has been paid to promote a certain brand, right? So maybe hashtag ad, that's pretty universal, Canada, US, whatever, we all have rules saying that. So what if it's a virtual influencer? Do the same rules apply or do different rules apply? India has explicitly said, so India's version of Canada's ad standards, so our advertising regulator, India has explicitly said, not only do the normal influencer disclosure rules apply, but the influencer and their creator and the brand, you all are obligated to make it very clear at the outset that this is not a human, right? So what you don't want is you don't want a viewer, just especially someone younger, but quite frankly, a lot of these look real even to adults, right? So you want any ads or social media posts, communications, whatever, to be crystal clear at the beginning, at the outset, that this is not a human. So I think that's something important for people in the current audience to keep in mind. Another risk with virtual influencers is the issue of cultural appropriation. So that's the example here. In this case, Shudu is, so the model on the right She is the virtual influencer. She was created by this person on the left, who is a human. He is a British photographer and he is Caucasian. So he has now created an all digital modeling agency, which, whose business is focused on championing diversity in the fashion world, right? So with his digital influencers, they might be used in the Prada or Calvin Klein, digital runways of the world. And so that's good because then there's more diversity from an advertising campaign perspective, high fashion, whatever. But some people think, or is that good? Because what's happening is if Prada were to use Shadoo, then they might not use a real Black human model, right? And then who's benefiting in this case? It's not the Black community, right? So that's an issue there. In terms of certain other legal issues, just as you would have an agreement with a human influencer, you still obviously need one in this case. And don't think that you can avoid having a morals clause, right? You still want to make sure that this virtual influencer and their creators, AI or not, are not going to do anything that will embarrass your brand. Maybe you don't want this virtual influencer to be associated with certain other brands that could cause problems for you from a PR perspective. Another legal issue to be aware of, I mentioned it earlier, is, the virtual influencer shouldn't really be saying, I tasted this and it's delicious. I've used this acne cream and now I don't have acne. So they can still promote yogurt or they can still promote acne cream, but I think you want to be a bit more careful, right? Saying something like, this is a really good acne cream, as opposed to this cleared my acne, right? So you want to make sure that they're not, there's no content that they're associated with that is just outright misleading, even if you do disclose that this is not a real person. So that's those are some of the key things to keep in mind regarding virtual influencers. And in the future, when you're scrolling online, maybe you can be on the lookout and see, is this a real person or is it not? Because sometimes it is very, very hard to tell. The next category of information that I want to talk about is dark patterns. So I find this also a very interesting topic. What is a dark pattern? So I've listed on the slide a definition, but essentially imagine it as a user interface which, deliberately or not, basically manipulates consumers into either doing something unexpected or doing something that they didn't want to do. And so this could be purchasing something, it could be subscribing to something, it could be not being able to cancel something when they want to, or it could be sharing more personal information than they realized. And the person who originally coined the term dark patterns a number of years ago, he basically defines dark patterns as dirty tricks to increase conversion rates. So it's a bit more concise, but that's a good definition. Why are dark patterns important? Many reasons. It is now, so if you haven't already heard this term, I think you certainly will in the future. This is on more people's radar now, whether it's consumers, public interest groups, or regulators. And for companies that engage in certain types of dark patterns, like the more egregious types, it's going to lead to bad PR, enforcement action, and potentially class actions. To combat the problem, Consumers Report and some public interest groups and some researchers, last year they launched the Dark Patterns Tip Line. So basically, consumers can anonymously upload examples of dark patterns. And it's a website. It's actually great. You should take a look at it, Dark Patterns Tip Line. The founders of that Dark Patterns Tip Line review the examples, they curate it, and then they post good ones with good descriptions and analysis online. And the point of this is it's multifold. One, so that consumers can go online and, educate themselves on the dark pattern examples that are out there. It's also so that researchers and, other public interest groups can go online and see what the trends are, see who the bad actors are, and hopefully foster some policy change in that way. But the reality is, whenever there is a website like this, where they're highlighting certain egregious examples, you're going to get regulators looking at that and figuring out who they should pursue. You're also going to get media looking at it, seeing who they can, discuss in the media and embarrass. You're also going to get class action plaintiffs saying this is an unfair practice. You need to pay back the consumers who've been hurt by this. So that's a website to definitely be aware of. Some companies engage in dark patterns inadvertently, whereas others do it, it's deliberate. And so the reason why I'm talking about this for this presentation is because as in-house or external counsel, it's important for you to be aware that, you may have a very good client and company, right? So not all of this is deliberate, but you're not aware that the designs and behavior that your marketing people are engaging in, that might not be perceived well. So what I'm going to do is I'm going to talk about some dark pattern examples, and then I'll give a bit of a legal landscape highlight afterwards. So I have 8 examples set up. We'll see how the timing goes, whether I get there. And there's many more examples beyond this. The first one is roach motel. It's like a cockroach trap, right? So it's easy for the roach to get in. It's hard for the roach to get out. That's what a roach motel is. And this is an example, New York Times, very easy when you want a subscription, but if you want to cancel, not as frictionless, right? You can't just click on something and say, I want to cancel. You need to call a phone number during their business hours. You can now, and it's not reflected on this screenshot, but you can now also, like through their chat, through their chat mechanism, cancel that way. But it's not as easy as just, one click, I want to unsubscribe. And Amazon is actually another example of a roach motel, because if you want to cancel your Amazon Prime subscription, it's not quite so easy. That's an example that's had some issues. Misdirection is another one. In the Western culture, when we see green, we assume that means go. When we see red, we assume that means stop. And so in this case, what the person wanted to do was they wanted to deactivate their account. But, this business didn't really want it to deactivate so easily. So they have this no, go back in green. And so some people might just, instinctively press green. So they're not actually deactivating, which is what they wanted to do. So that's an example of misdirection. The next one that I wanted to discuss is something called confirm shaming. So the caption, which I think you can read, is, why does my dog do this? And the reason why they're asking is because, do you want to sign up for the dog's free, or for the company's free newsletter? If you do, enter your email. You probably can't see this, but what it says is, no thanks, I don't want to understand my dog. So that's the wording, right? So it's confirm shaming you. You can imagine if an insurance company did this. Do you want an email about, the insurance product, like the disability and life insurance you can buy? No thanks. I don't want to, protect my children, right? Things like that. So that's an example of confirm shaming. Sneak into basket. What that means is, you're not expecting something. So you've gone online shopping, and at the end you're expecting to check out, but new things have been added. And some of us are more aware. And so we see that. It's like, well, I didn't put that in. I'm gonna remove that. And that's kind of annoying, right? Like, it takes us we don't want to take those extra three seconds to remove it. But also there's various people who don't even notice. So they're just going to actually pay for it. They bought it, they paid for it, and they don't even realize it until they receive it. When they receive it, they might think, oh, this florist was so nice, they gave a free card, or, you know, things like that. They don't even realize that they paid for it. So an example would be you buy flowers, you get a greeting card added to your basket, or you get a vase added to a basket. Another example is you're buying electronics and a warranty is added to your basket. And to be clear, I'm not saying that, you know, you're buying an electronic and that at the end, when it comes time to check out, the site says, do you want to add a warranty? I'm not talking about that. I'm talking about when it's already added and the onus is on you to opt out. Another example is trick wording. So in this case, you know, you had to include your contact information because you wanted something, you wanted to buy something or reserve something. And then they have these marketing statements at the end. And typically the marketing statement would be, you know, I'd like some newsletters or something like that. And if you want it, you click, right? So it's opt-in. In this case, you've got two statements which are different. So the first one says, please do not send me details from the business. The second one is, please send me details from third-party organizations recommended by the business. So if you didn't want anything, then what you should do is you should click the first one, but not click the second one, or the reverse, right? So basically trick wording, the fact that you have to actually even think about it. So that's what they mean. Privacy zuckering is basically when businesses are getting more of your information than what they've disclosed to you, or using it in a way that they haven't disclosed. There's obviously a whole bunch of issues from a privacy perspective, so we'll just leave it like that. That's the term they use there, privacy zuckering. The next two that I will talk about are hidden charges. So hidden charges, the difference between this and the earlier one, which is sneak into the basket, is sneak into the basket is technically optional. You can actually opt out if you see it, right? You can remove it. Hidden charges, you cannot. So the example here would be like years ago in Canada, the Competition Bureau, had enforcement action against airlines, rental car agencies, ticket sellers, because they would add various non-mandatory surcharges, but it wouldn't be advertised, right? So there was a ton of enforcement action there. But in this past summer, actually, the Competition Act was actually amended to explicitly prohibit that. So to have hidden charges is actually not allowed. Now, so in addition to it being a dark pattern in Canada, hidden charges, which are not mandatory charges, that's actually not allowed. In this case, so this is an example of an amusement park. So if you want an amusement park in Canada, so if you want to buy a ticket or a season's pass, you put it in your cart, and at the end, a processing fee pops up that I don't think was disclosed earlier, and so that's not great, right? So other examples are admin fees. Another example is, sometimes you need your client or whoever consumer to electronically sign something. So there's been cases where if the company says, well, I'm going to give you a DocuSign so that you can sign it, and I want to charge you for that. So all of the hidden charges are dark patterns, and some of which are just explicitly legally not allowed. The last one that I'm going to talk about is fake urgency scarcity. So I'm sure that many of us have been on, whatever travel or hotel website, and then you'll see things saying things like, only 3 left, or, in the last 24 hours, 1,000 people have looked at this site. Or for cruises, it might be like, you've got 10 hours before the sale expires, and yet, like a week later, it's the same sale. So that's fake urgency scarcity. And if the information is accurate, then it's not fake urgency scarcity. But if the information is not accurate, then that's a dark pattern, and that's very misleading. Okay, in terms of just the legal landscape, then I wanted to flag a couple of things globally, because in Canada, we don't have, or I'm not aware of any law or frankly guidance from regulators which explicitly use the term dark patterns. But I will talk about what Canada does have after. But first, I want to talk about the US a bit. So last month, the US Federal Trade Commissioner issued a press release on the Bureau of Consumer Protection's staff report called Bringing Dark Patterns to Light. And a few years ago, the FTC had a workshop regarding dark patterns. And this sort of consolidates some of its findings from that workshop and other research, other investigations. One of the things they say is more and more companies are using digital dark patterns to trick people. These traps will not be tolerated. Earlier this year, the FTC also issued an enforcement policy. So that enforcement policy was specific to subscription services. And in that case, they basically said, what's the wording? Firms that deploy dark patterns and other dirty tricks should take notice. So, FTC already has an enforcement policy dealing with dark patterns in the subscription context. And the FTC is, sometimes ahead of the Competition Bureau in terms of enforcement. So definitely in Canada, we should be prepared for this. In terms of the EU, this is the EU body that applies the GDPR, so European privacy, and they now have draft guidance on dark patterns in social media platform interfaces. So where does Canada fit in here? So in terms of Canada, as Jamie Lynn mentioned, so earlier this year as part of Bill C-27, there's been two things actually. So one, the AI and Data Act was one of the acts. The second one was the Consumer Privacy Protection Act. And as she mentioned, it's at first reading. So the Consumer Privacy Protection Act, it will be the sort of modernized PIPEDA. And under the proposed wording, what it says is an organization must not obtain or attempt to obtain an individual's consent by providing false or misleading information or using deceptive or misleading practices. Any consent obtained under those circumstances is invalid. So basically under the proposed new PIPEDA, new privacy legislation, it is explicit that if privacy consent was obtained because the business provided false or misleading information or used deceptive or misleading practices, which is essentially dark patterns, in that case, consent will be invalid. And this actually is similar, well, same as certain states in the US, because in the US, privacy can also be governed under state law. And there's several states, California, I think it's Colorado, and at least another one, where beginning next year, they have privacy amendments that will come into force, which explicitly says that privacy consent that was obtained through dark patterns is not valid. So under those US state laws, they use the term dark patterns, and it's very clear. Whereas in Canada, though we don't use the term, that's basically what a dark pattern is, right? It's a deceptive or misleading practice, and this encompasses more broadly. Even without this new legislation, Canada's existing legislation also covers it to some extent. So for instance, we have consumer protection laws which prohibit unfair practices. Under the current privacy legislation, we have that meaningful consent policy, which means that organizations are only considered to have consent from a consumer from a privacy perspective if the consent was obtained in a way that is basically, the consumer understood what they were doing when they gave the consent. So even though we don't have wording that necessarily uses a dark pattern, wording. We do have laws already which kind of protect consumers, but certainly to be more explicit is better. In terms of what businesses can do to minimize the risk of engaging in dark patterns, a couple of things here. That's self-explanatory. A couple of other things: avoid manipulative copies. So the example about the dog, don't mislead, the behavioral psychology examples, like in terms of red and green, and also, again, AI is pervasive, right? So AI, you want to be careful in the future when you're using AI, because you can use AI with dark patterns. So an example of that would be, they see that I'm too lazy, or I didn't notice that there was something added to my cart, and so I didn't remove it. So in the future, they target me using AI, and now it's going to be an even more expensive add-on, things like this. And as Jamie Lynn said, that's really dangerous, because under the AI Act, if there's economic loss due to your AI system, or if there's biased output, you can be organizations can be really, really penalized. So definitely be careful of that. And Jamie Lynn will now be talking about NFTs.
Thanks, Alice. Oh, I find both of those topics so fascinating. Especially virtual influencers. That's just so funny. I don't know. Maybe I have encountered them and just wouldn't know. They do look so lifelike.
It's true.
I promised that I would leave 10 minutes at the end for questions. I think I can fit my NFT topic in and still live up to my promise. So here we go. I want to start off by saying that I have colleagues at Smart and Biggar who deal with NFTs way more than I do. But since we're talking about digital advertising here today, how can I not mention it? So what I'm going to do is I'm going to share a fictional case study of how NFTs can fit into a marketing campaign and some of the legal implications. But if you want to learn more about NFTs, a bit of a deeper dive than what I discuss here today, I invite you to rewatch my colleague Daniel Anthony's presentation on this topic as part of this same webinar series, which is currently available on our website. So a little plug there, a little cross promotion to my colleague. So first, what is an NFT? It stands for non-fungible token, and it's a unique identifier. It can't be copied. The fact that it's non-fungible means that it can't be interchanged. So it's not like cryptocurrencies, which are mutually interchangeable. NFTs are not. An NFT is recorded on the blockchain, which that's a digital ledger, and it certifies authenticity and ownership. And an NFT usually represents an underlying digital asset, such as a digital work of art. So now that we understand, or at least have a basic understanding of what an NFT is, we can move on to our fictional case study. So let's imagine that our client is a luxury automaker, and they're releasing their latest model of electric vehicle. To generate buzz for this release, they're going to give customers an NFT with the purchase of every vehicle. So the NFT is going to represent a virtual vehicle, a virtual version of the vehicle purchased. So what are some of the legal considerations that our client should bear in mind when contemplating this NFT promotional campaign? The first legal issue that typically comes to mind when we talk about NFTs is copyright. It's important to note that the transfer of an NFT does not automatically transfer the IP in the underlying asset. So imagine, for example, that you purchase a limited edition print, which is signed by the artist. That print is like your NFT. Now, there might be other prints out there that look just like yours, but yours is signed and authenticated. So while you have the right to own the physical print and hang it in your house, you can't make copies of it and distribute it to others, because that would infringe the artist's copyright in the work. In our fictional case study, our automaker likely owns the copyright in the virtual vehicle, the piece of digital artwork, because it was probably drawn by an employee of the company. And they probably are going to want to hold on to that copyright and limit the manner in which the customer who receives the NFT may use and display the work of art. So these terms about ownership of the copyright and license to use should be set out not only in the NFT smart contract, which underlies the which underlies the NFT, but should also be explicitly provided to the recipient so that the terms of their ownership and the license are clear when they receive it. Another legal issue is trademarks. If this is the client's first foray into NFTs, it's entirely possible that the trademark portfolio is not up to date. For example, while our automaker might have registrations for its principal trademark covering automobiles, it might not have any registrations covering digital automobiles or NFTs. Since NFTs and digital assets tend to fall into different classes than the real world products they represent, there is probably a gap in protection for this new scope of activity that the brand might want to fill. A third legal issue is securities law. And there's a bit of a question mark as to whether NFTs are considered securities for the purposes of securities regulation. I mean, the fact that something is non-fungible means that it's less likely to be a security. However, NFTs might cross the line into securities territory if they are fractioned, meaning partial ownership is permitted. Now, since we don't have any definitive position by Canadian securities regulators yet, there's no clear answer. So, the advice that we can give to our automaker is that it should tread with caution. It can minimize risk of its NFTs being classified as securities by preventing them from being fractioned, preventing their resale, and only giving them away for free. And with that, I have left us 8 minutes for some questions and answers. And so I can open the floor. So let's see them in the Q&A box. And I think Alice, you're gonna moderate for us.
Sure. So the first one is, if a virtual influencer says that yogurt is the best, is that, let's say it's a false misleading rep, who would be responsible? So in terms of, maybe I'll change it to something like, if a virtual influencer says that a mattress gives you the best sleep, or if a car gives you the best ride. And the reason I'm going to change it is just because that is a bit more specific in terms of why it is the best. Maybe more people would rely on that. In that case, I mean, honestly, either could be responsible, the brand or the influencer and the creator. In Canada, enforcement has been more with respect to the brand, but certainly in terms of FTC, they've been more, there's been more letters directly to influencers as well. And I think the only reason why it hasn't been more, focused on the influencers themselves in Canada is because, it depends if you're a major, a macro or a micro influencer, right? Like, I mean, who do the regulators want to spend their time on? If they take action against the brand, maybe industry is more likely to follow suit and be more concerned, but both could potentially be responsible. Yeah, so I mean, in terms of, if you were to say, if you're a virtual influencer and you were to say, I had the best sleep, I think that's a problem, that's a problem, because as I said, they didn't actually sleep on it, right? And everything they say does have to be correct, right? Because you're basically the brand ambassador, brand rep. What else? Another question is, for NFTs, is it necessary to own a trademark registration covering NFTs or digital assets if you already have a registration for the same trademark for the real world product?
That's a great question, and one that in Canada we don't have an answer yet from the courts, because this is just new territory. What I can say is that what we're seeing is major brands are filing for NFTs. So major brands who used to previously operate in the physical world space, they're now protecting their brands in the digital space. There is a question of whether, can you enforce a trademark for physical products against the use of the same trademark with the digital products? Well, the question would be, is there consumer confusion? So you don't necessarily need to have the same goods in order for there to be consumer confusion. If the consumer is likely to believe that that digital product is provided by the same source as the physical product, then there's confusion and then you have infringement. And so theoretically, your registration for that physical good should be enough. But that's a harder test. It's much easier to enforce a registration for the exact goods that are being sold by the infringer. And so, for that reason, I think that's why brands are taking a little bit of a proactive approach in the NFT space in order to expand their portfolio there. And I think it also it shows that they're on the cutting edge to a certain extent. I think that there's some good PR in showing that you're taking steps in that digital world, the metaverse, and all of that.
Thanks, Jamie Lynn. Okay, another one. What are some other examples of dark patterns? So some of the other ones are something called forced continuity. And that's when you start a trial, like a free trial, and after a while you're going to be charged, but you're not reminded of it. So that would be an example of forced continuity. And again, this is interesting from a legal perspective, because if I was clear to if my ad was clear up front that I'm going to charge you after 1 month, I don't know that it's on me to necessarily remind you, right, that we're going to charge you because I told you when you signed up for the free trial. But that's considered a dark pattern, which is why from the in-house and external lawyer perspective, some of this is gray and some of this is expectation, and maybe or maybe not it's a legal issue, but it's not good from a reputational issue. A couple of other dark pattern examples: disguised ads, which are advertorials that are disguised to look basically ads, but they're disguised to look as though they're actually a an editorial, and I've seen this, right? So I've also seen this from really reputable companies. So, and sometimes even the reputable companies don't necessarily think that what they're doing is necessarily wrong, but if it's not clear to the person, if it's not clear to the reader, the viewer, that the reason why you have this editorial is because you actually sell a product, then that's a bit of an issue. Another example is, maybe a final example. The one that I actually really dislike is when I can't get out of something. For instance, if I actually don't see the X, so you know how there's an X on the right-hand corner of things, and then you can close out that thing. Sometimes I can't, like, it's not often, but I can't see it, and that's deliberate. And that is actually really, really irritating. There is another question in terms of what can you do for dark patterns? I mean, maybe you call that dark pattern hotline. You submit it through, not that you call it, you submit a question through that dark pattern hotline that I mentioned. There's other dark pattern websites that you can submit things to. So the original person who coined the dark pattern term, he also has a website, although now it's actually called Deceptive Design. And the reason why, for two reasons. One, because it's more clear and more accurately reflects what the issue is, and two, to be more inclusive. And he actually has a hall of shame of dark patterns. In terms of Canada, I'm not aware of a dark pattern specific hotline for Canada, but certainly, you can complain to the file something with the Competition Bureau, for instance, right? And make sure that it's on their radar. We are at 1 o'clock. It was our pleasure to, present this. We found this to be, 4 really interesting topics, so we hope you did as well. And again, if you can remember to complete the survey, let us know what we can do better next time. Let us know which particular topics you might be interested in hearing from either us or our colleagues. That would be appreciated. And Till next time, thank you.
Thanks so much.